We're glad you can make it. My name's Craig Riffle. I'm an attorney and CPA. And I have with me today, I have Ryan Baldwin, I have Alana and Jessica, and they're going to help us today. What we're going to talk about, and I want to give special thanks to MedicRx. They are a partner with us in this. But we're going to talk about power of attorneys. And why do you have a power of attorney? We're going to talk through it. We're actually going to walk through a power of attorney so that you can see what it is, why we have it, that type of thing. And then we're going to, if you want one, you can have one when we're done. We've set up a workstation in the back that we can actually draft one, so we're going to walk through a power of attorney. I don't know about you guys, but I'm the kind of person, if I'm going to do something, I have to understand why. Why am I doing it? What do I need it for? That type of thing. And the power of attorney is a very important document. There's two types of power of attorneys. There's financial and there's health. A power of attorney is a very important document because what it does is it authorizes someone to act for you if you can't. Now, I'll use myself as an example. I'm married. My wife's name's Katrisa. We have two children, a 21-year-old and a 25-year-old. Now, if, heaven forbid, if I should happen to be in an accident or suffer from an illness or whatever, and I'm not deceased, I'm still living, but I can't make my decisions. My wife cannot do that for me just because we're married. Some people think that's the case. That's not the case. So she has to have some kind of legal authorization to act for me. Or my children, if they're going to act for me, they have to have some kind of legal authorization. One way to do that is with a power of attorney, and that's what we're going to focus on today. Another alternative is to use a guardianship. Now, a guardianship is court supervised. I was talking to a client this morning before we came down. Guardianships can be very time consuming and very expensive. In other words, a good example is, let's say my wife did not have my power of attorney. I had not appointed her. And she has to go to court and be my court-appointed guardian. The first thing she has to do is she has to file a petition with the court, allege that I'm incapacitated. Then she has to put on evidence to that effect. Now, the court's going to appoint me an attorney automatically to protect my interests. So she's represented, I'm represented. She's going to put on evidence as to my incapacity, and because what she's seeking is a court declaration that I'm incapacitated and I can't handle my affairs. Now, although I'm fully competent today, she may already be seeking that as we speak. But in any event, what happens is she gets that court declaration. Let's say it's successful. The court appoints her my guardian. Then she's required to file a plan for the care of my person. In other words, what's going to happen to me. A plan for the care of my assets. How are they going to be managed, whatever it may be. And then every year I'm alive, in an inventory of my assets, and every year I'm alive on the anniversary date, she's required to file an accounting of what's happened the past year plus an inventory of assets. And that goes on as long as I'm alive. It ends whenever I pass away. The alternative to that is a power of attorney. I think power of attorneys are very good things. Like I said earlier, this is my 30th year of practicing law. I've always recommended people have them. There are some slight disadvantages with them. One is let's say that the case I was talking this morning about was an individual lady had called about her mom, and she has a power of attorney, but it doesn't restrict you from acting for yourself. And in her particular case, her mother was being scammed, for lack of a better word. So although you appoint someone on the power of attorney, you still can act for yourself, which is a good thing, unless you have a situation where you're acting for somebody and they're being scammed or taken advantage of. So the power of attorney, signing a power of attorney does not remove your legal ability to act for yourself. Okay. Power of attorneys can be set up to where they're effective when you sign them, or they can be effective based upon doctors. Usually it's two physicians' opinion. It's usually your treating physician and a concurring physician. I like to set them up, especially in a husband-wife situation. I like to set them up where they're effective immediately, because probably husband and wife are probably already acting for each other. They share bank accounts and things like that. It just avoids having to go get those doctors' opinions later. If it's a situation where it's more of a distant relationship, you were talking earlier about trustees that were not related. Let's say that we have a power of attorney, we're appointing someone that's not related. Then in that situation, I'm probably more encouraging to make it effective upon incapacity, that type of thing. But any questions at this point? I think what really helps, I've done this in the past, and what really helps is we're going to walk through a power of attorney form. And we'll walk through it, and we're going to talk about what it is, the provisions, what do they mean? One of the things I did share earlier, power of attorneys, the Oklahoma legislature modified the power of attorney statutes effective November of 2023. If you happen to have a power of attorney that was signed before then, those are grandfathered in. But if you have one that's signed after then, it has to comply with the new act to be effective. What we are presenting today is effective with the new act. And so this is all modified for current information. You ready? All right, let's look at the first one. What we do typically is we start off with a paragraph talking about obviously identifying. Now, I will say all this information has been mocked up. It's false information. But we've just to kind of give you an idea. This is an example. We like to recite the legal name and then also how you sign that name. A good example is my full name is Michael Craig Riffle. I never used Michael. I never signed Michael. If you look at all my legal documents, it'll probably have Craig on it. There's nothing wrong with doing that. Some people think you have to sign a legal document. You're required to sign your full legal name. You are not. You can sign it however you want to sign it, and I prefer to sign it as just my middle and last name. So we try to recite that to make sure it gets clearly identified. Where you live, the county of residence, and then the state. This is not where you're signing it. It's county of resident. Date of birth, and then the last 4 digits of the social security number. The reason we put those two in it is because you're going to see later we have a HIPAA release in this information. Now this is a financial power of attorney, but it's going to have some appointments under the Guardianship Act. If you ever have a guardian appointed, you're entitled to name who you want that to be. If you don't name that, then there's a statute that defines that. So absent any kind of, appointing a guardian for you, if there's a situation where that needs to happen, even if you have a power of attorney, let's say there's a dispute between power of attorneys, or maybe someone's taking advantage of you or whatever it may be, for whatever reason, there needs to be a guardianship. The guardians that are appointed are the ones that are named whoever you nominate first. If you're married, spouse would be second, then adult children, and on down the line. So the reason we put that in there is that because we will have a HIPAA release because of that nomination, and that information is required for the HIPAA release. Okay, section 1 is just some basic background information. He talks about the power of attorney. Hold on just a second. Talks about the act. Talks about what your agent can do and those type of things. This is required under the new act that was effective November of 2023 to be in the power of attorney. And so it talks about some instructions. That these provisions were not required under the old act, but they are now. And so if you'll scan on down. Then what we do in section 2, we designate the agent. Now, section 2 is the person that you want to serve first. In this particular case, you put this together. Is Susan his wife or, I guess spouse, okay. Yeah. So John is naming his wife Susan. A lot of times people will ask me, and this is a good point to talk about this, is can we name one person? Do we get to name more than one? I mean, how does that work? You can name as many as you want. You can name them to act together. You can name them to act individually. So the big concern that we always have is who do we want to name first? In this particular case, John's saying, I want my wife Susan to serve. Now this information, we always, even under the old act, we had to identify obviously by name and by relationship. But now we have to also identify by address and phone number. Sometimes we'll ask people, you're going to name someone, I need their phone number. And I always, to make them feel comfortable, I always tell them, I'm not going to call them, but the statute requires I identify them by phone number. That's why we have to put it in there. Now, if that information changes, one of the questions I've gotten over the years is, well, what happens if this information changes? Obviously, this may or may not, this one here, but if it's like a daughter, that wouldn't. But what happens if this information changes? Do I have to redo my power of attorney? The answer is no. It's whatever that information is at the time you sign the power of attorney. So for instance, if the address changed or the phone number changed, you don't have to redo that power of attorney. It's still effective. In this particular case, John is naming Susan, spouse, to be power of attorney. What happens if Susan can't serve? Well, that's where section 3 comes into place. And in this particular case, if you'll scroll this up a little bit, what's happened under section 3 is John has said Susan's going to act first, but if Susan can't act, I want Emily, my daughter, to act, and this is where she lives. And if Emily can't act, Angela then acts. Is there another one down here? Then David acts. So what's happened in this case is they've named successor power of attorneys consecutively, one behind the other. What was it? Emily, Angela, then David?
Yep.
Okay. They could have said, sometimes people will say, well, I want them to serve concurrently. I want Angela. What's the other one? I can't remember. David and Emily. I didn't know you were going to test me today. There's going to be a test. I should have studied it for again. So Emily, Angela, and David, if they could say, we want them to serve together. In this case, they didn't say that. They said, we want one, then the next. Now, if you say you want them to serve together, the next question is how do you want them to serve? Meaning, how do you want them to act? If you have more than one acting together, does it require both their consent? The three alternatives you have is either let's say instead of it being consecutive or consecutive like this, let's say they were serving concurrently together. Well, with three of them, we have the option of they all have to agree, unanimous consent. We have the other end of that spectrum is that anyone can act independent. I've named three, but they can all act, each one of them can act independent of the other. Or it could be majority vote. Now, if there's two, there's no such thing as a majority of two. It's either unanimous or independently, right? So that's the next decision. But in this case, we don't need to know that. We want to spell that. I'll show you here in a minute where we spell that out. We spell that out in the power of attorney because remember how this document is going to be used. If my wife needs to act for me, let's say that she's trying to act for me with you. I can't do it, but you need my signature. She's going to take that power of attorney and or my kids, let's say my kids. Let's say my wife can't do it, but I told you I have two kids. My kids are going to take that power of attorney and say, here, we can act for dad. Well, you're going to want to know, we want you to take this power of attorney and accept it, right? And use it instead of them having to be appointed a guardian. But you're going to want to know, well, can his son act for him? Can just his daughter act for him? Or does it take both to act for him? That's why we want to spell that out in the power of attorney. So right now, what they've done in section 2 and 3, they've simply said, okay, spouse is going to serve, and then we're going to go through the other individuals. If you go down to 4, scroll down to 4. Okay, this is another section. This is totally different than the old act. What the legislature did is they came in and they said, look, there's certain powers that when you grant power to the person to act for you, we want you to initial that they have the power to do that. Under the old act, you could just say, I want them to act for me, period. I want them to do everything I can do. This one requires that you go through each one and you initial that, yes, I want them to deal with real estate or personal property or stocks, if you'll scroll on down. Now, what you can do is you can say all preceding subjects. So you can just initial the bottom one and say, I want them to do all of those things for me. Or you can limit it. You can say, I just want them to handle my taxes. Or I want them to handle my bank's information, whatever that may be. Most people, they'll ask, what do you think I should do? If you're going to appoint someone to act for you as an agent, I would encourage you to give them all the authority to do that. The critical question is, and I would look at it this way. If I have a concern about that person being able to act for me in a certain capacity, they probably are not the person to be my power of attorney. Okay? I think it's more critical that you give some thought as to that appointment and who you want to have serve. So what happens is you decide whatever it is, but you can limit it on whatever it is, but you can select all subjects. Now, this is a little different than the next section. This section deals with dealing with your assets. Let's go to the next section. I need section 5. Go down some more. No, the other way. I need section 5. Sorry. Okay, so section 5 deals with, you've got to give specific authority for each one of these. There's no line at the end that says, I want them to do it all, because section 5 deals with specific things regarding the disposition of your assets. Remember, section 4 dealt with dealing with assets on your behalf. Section 5 deals with acting on your behalf, which could affect the distribution of your estate. So let's look at what they are. Okay, scroll up now. Okay, for instance, you don't have to, but you can give them a power to amend or revoke a trust. This one is the power to make gifts, change the rights of survivorship on accounts, beneficiary designate. If you look at these, every single one of them deals with acting on your behalf that's going to affect the distribution of your property when you die. So as a result, if you want them to have that power, you have to initial each one. Okay? Let's scroll on down. Section 6 talks about some limitations regarding the power of attorney, talks about what they may not use, do as your attorney in fact. Think of it this way. Your power of attorney is your agent. Your power of attorney owes you fiduciary obligations. And in a nutshell, the best way to think of that is your power of attorney must act in your best interest, which generally means that they've got to act in a way that they would want someone to act for them. They cannot go out and handle your assets or do things on your behalf that's not in your best interest. Now, I'll tell you as a lawyer, the best thing to do is select the right power of attorney. Although the document requires them to do that, it's much easier and better if you select the right person than it is to select somebody that may or may not be the right person, and then we got a problem we got to deal with. I'll give you an example. Had a lady in my office. She had 3 children. She was trying to select for her financial power of attorney which one of those 3 children she should pick. Now, I shared with you earlier, I don't like to tell people what they should do on their planning. I just try to help guide them. And I tell them often that I don't know your children as good as you do. Okay. But when she was thinking about that, she selected son Tommy. I said, tell me about Tommy. Well, he's had his problems. Okay, now I really want to know about Tommy. What do you mean he's had his problems? Well, he had some drug charges. Okay, what else? He's filed bankruptcy. What else? He's had financial problems. Probably not the best selection for your financial power of attorney. Let's think about someone else. I've had other situations where, and there's not a right or wrong answer how you do it. I've had other situations. I remember one lady in particular, she had 2 children, a banker and a nurse, and she appointed the banker as the financial power of attorney and the nurse as the health care. That was just the way she liked to do it. There isn't any reason they couldn't both serve on both of them altogether. So anyway, Section 7 talks about special instructions. About the copies, the same effect. If you have if you have one that's been executed prior, this would revoke that one. In other words, the last one that's signed is the best one. If you'll move it up. We do have there's a gift provision, and here is the HIPAA release provision. This created quite an issue. Go back. This created quite an issue. I had a lady call me one time. Her mom was from Fairview, and her mom had signed HIPAA releases with her doctor and hospital. You guys know what HIPAA is. It's the thing that doesn't let the medical providers disclose your medical information. They had signed HIPAA releases with the physician in the hospital. But mom got transported to a hospital in Enid. Okay, now the daughter was appointed as the agent under a power of attorney. Legally, that's just like talking to mom. She steps in mom's shoes. It's just like you're talking to mom. But I couldn't get the hospital to release the information because they didn't have a HIPAA release. What we found out is it's easier and more effective if we include the HIPAA release in the power of attorney, because that way it doesn't matter where mom ends up. That HIPAA release is going to follow mom because it's specific to the power of attorney. It's not specific to the institution. When you sign another HIPAA release, when you go into a hospital or doctor or whatever and you sign a HIPAA release, read the top of it. It will say, I authorize this entity to release my information. It's specific to the entity. So usually it's best to include the HIPAA release in the power of attorney. Go ahead and scroll up. In this particular case, since we're appointing spouse, We're making it effective immediately. This is where we would say, if we didn't want that, we would say, no, it's not effective immediately. It's going to be effective based upon my incapacity. So right now, my power of attorney is like this. It says that it points to my spouse. She's on most all of my accounts anyway. We've been married 33 years, and so it appoints her, and so mine's effective immediately. What I could say in mine is I could say, no, I don't want it effective immediately. I want it effective based upon if I should become incapacitated. Now, the only problem with that is, in order to make it effective, if that event ever happens, she has to go have me examined and get 2 doctors' opinions that I'm incapacitated. This is the provision that talks about nomination of a guardian. If a guardian is ever needed, you get to nominate those in these documents. This one pertains to property. So in this particular case, if you'll scroll up, in this particular case, John, I think it was, right? He appointed him to serve in this order. And this order typically is the order that you see up above in Section 2 and Section 3. But again, they're identified by name, they're identified by relationship, they're identified by address, and they're identified by phone number. What's a little unique about this, and we've talked about the fact this is a financial power of attorney. Well, why do we have healthcare information in it then? Why do we have a HIPAA release in it? The reason we do is because of the next provision. This provision, this one deals with property, but this one says, who do you, stop, back. Sorry. 902. Who do you want appointed if for your person, for you individually? And so what happens is this is to take care of you. Now, what's a little strange about it, and the reason it's this way, is because we used to, like I said, prior to 2023, we used to have healthcare power of attorneys, and they weren't anything like this. Then what the legislature did is they came in and they did away with healthcare power of attorneys. And all we had was this, which was a financial power of attorney. So as a result, they put the provision to name someone to act for you in here. We do have healthcare power of attorneys now, but that's why this is in here. So in this particular case, this is to act for your property up here. This is to act for your person, and then it names each one of the individuals. Again, names them, identifies them, address, and phone number. If you'll scroll up. This just basically is required by statute to say anybody relying upon this is not going to be liable. In other words, if they accept it, if they present it to you and you accept it, you're not going to be liable for filing it. It has to be signed. Go ahead and scroll up. And notarized. Then if you'll go ahead and scroll up. There's some additional information about, it is required that whoever drafted it put their information on here. Then this other information regarding, these is instructions to the agent. What I was talking about earlier about acting under fiduciary duty and good faith and that type of stuff, this is required, these admonishments are required to be on the power of attorney. It also even explains how you sign the power of attorney. That's information for the agents. Agent being the person that's acting for you. You draft these all the time. Anything I missed? Something you find that's important? Questions? Now, someone asked me one time, do I have to have a power of attorney? No, you don't have to have a power of attorney. And if you never need, what I always like is people will say, I've had a guy one time, we were talking about a contract, and he goes, well, I didn't have a contract like that last time. I didn't have a problem. Yeah, because the problem didn't come up. You don't have to have a power of attorney. If you're never incapacitated, you'll never need a power of attorney. But back to what I was telling you about my spouse, if you hit a situation to where you're incapacitated and you can't make decisions, you're going to either have to have a power of attorney or it's a guardianship. It's one of the two. Now, if you guys want a power of attorney today, we'll be glad to get it for you. It won't cost you a dime to have it. If you don't want one, that's fine too. We're happy to stay as long as you want to and answer whatever questions you may have or regarding the power of attorney. I think they're important. Like I said, they're documents I've been encouraging people to have my entire career simply because, to me, it's a difference in spend, of course, it's not going to cost you anything, but when I'm dealing with clients, I tell them, look, it's a matter of taking a half an hour's worth of time and drafting a power of attorney and you're done versus a whole full-blown guardianship. So if you already have power of attorneys, you should review them and make sure they're current.